Any mention?
Lordship. Item 44. Item 44.
Yes.
This is a revenue matter. Lordship, there was an order to produce the relevant record.
44.
44. And the records which are produced, those are actually not relevant. Those are the records of the CEM. What we need the records relating to the passing of order dated 23/10/2019 by the Assistant Settlement Officer. Without that record,
44.
even in the prayer that was there, that the relevant record.
So, Mr. D, why don't you put the correct record?
My lord, these are the record which has been sent directly, my lord. I need to examine whether the relevant, whether it is
You check the records.
Yes, your lordship. These are only the CM.
I'll go file it. They were called by which date? Which order?
23/10/2019. This is an order.
Which order? By which order was the records called?
The first order. First order.
First order?
At the motion stage.
Yes. No, not motion stage. Yes. As this
Produce
matter,
the relevant record.
yes, as this matter could not be settled by mediation, the same is has returned to the courts. Ms. SD on 15/5/2025 had submitted the records with regard to the land documents. However, Mr. Vicky General Senior Counsel has submitted that the land records which have been produced
Yes.
do not include an order dated 23/10/2019
19 passed by the Assistant Settlement Officer.
So he prays that directions be issued for production of the said records.
And on if produced, I may be allowed to inspect.
That's okay. Let them come. Let them come. They will allow you here only. Mr. SD, next paragraph, submits that 2 necessary reports will be produced, and that 2 weeks time be given. Accordingly, just not for 2 weeks for production of the relevant record.
Lordship, I beg to mention item number 45 of the main list, Lordship. I'm praying if this matter can come.
You'll do it.
Lordship,
You're the main counsel now, as seen from Mr. Paul's chamber.
Lordship, Learned Senior Miss A. Paul is leading, Lordship, in this matter.
No, but you're the main counsel now.
Lordship,
Correct.
Lordship, I'm praying, Lordship, if this matter can be taken up after a week.
How many times adjourned it
Lordship,
on this excuse?
Lordship, she has some personal difficulty, Lordship.
Last time also.
Lordship,
Yes, Dr. Mozika.
Lordship.
That survey map is there. That's only that remains. It's only for determination of whether they had one portion of their
pillar number 11 and 12.
Yes, then
Lordship,
you tell your senior, say that the court has expressed that the matter should be disposed of.
Lordship,
We can
1 week time, Lordship.
We can adjourn it just.
Lordship, I quite follow, Lordship. 1 week's time, Lordship. Lordship.
Take down Mr. S. Chanda has prepared for adjournment of the matter due to the unavailability of the learned senior arguing counsel. Stop. It is noted this matter has been adjourned repeatedly. So it's expected next date no further adjournment will be taken. Just after 2 weeks. Yes.
Lordship.
May please, Lordship. His Lordship, I beg to mention item number 46, my lord. I have informed to the other private respondent also. Here. 46.
No objection.
No objection.
Yes.
Much please, Lordship.
Please, Your Lordship. Lordship, item 41, Your Lordship. 41.
41.
Lordship.
They'll send you for heavy duty. Just go down and adjourn it.
Lordship, they'll come on Friday, Your Lordship. Senior is having some difficulty today.
Yes. 41.
31 or 41?
41.
41.
May I see them?
HSPS property.
Who's for a comment?
I'm there, Your Lordship, for asking. In fact, this matter can be closed, Your Lordship.
Friday, Your Lordship.
Yes. Repeated adjournments. It's also been adjourned repeatedly.
Lordship. Well, Your Lordship, the counsel from government side is not.
It was absent for a long time. That's why he forgot about the matter.
No, Your Lordship.
Petitioners, yes, let's see. Request petitioners. Last time, see, Mr. S. Karyam. 9/4/26 S. Karyam. 24/26 S. Karyam. 93/26 S. Khatun. 25/2/26 Thappa. 26/11/25 S. Karyam. 11/25 was a court mid observations. Last adjourned by them was on 17/10/25. Yes, sir. Today again, brave adjournment has been made on behalf of the petitioner. It is noted this matter has been adjourned for innumerable number of times. Stop. Mr. S. Karyam, you will argue the matter next date.
Lordship, my senior is leading this matter, Your Lordship.
Tom, no? Stop. It is noted that this matter will be adjourned for innumerable times at the request of the petitioner. Stop. However, in interest of justice, further 1 week's time is allowed. Expected on the next day that no further adjournment be taken.
Please, Lordship. I'd like to make a mention on item 48, Your Lordship.
Item?
Item 48. I pray for 2 weeks' time, Your Lordship.
May it please Your Lordship.
48.
48.
But what's happened is matter?
Lordship, that Nehu, Your Lordship. Lordship, there was a meeting, Your Lordship. Government has taken to the Nehu, Your Lordship, to take over the property, Your Lordship. Now, Your Lordship, the state has brought into the notice, our notice, Your Lordship. There is an agreement of 1983, Your Lordship. Lordship will permit us to file that document. It's a very vital document, Your Lordship, to define it.
Yes,
Lordship.
Mr. N.D. Shulai, EAG, submitted that in this matter, the state respondents would require to file an additional affidavit,
Lordship,
to bring on record document.
An agreement, Your Lordship.
An agreement dated executed
1983, Your Lordship.
1983,
Lordship,
which would have a
bearing on the
incident matter.
Lordship.
The same is not objected to by MS Dhar for the petitioner. Yes, how much time required?
Let it be 2 weeks, Lordship, because I have to
Yes, a matter.
typing is to wrap.
Yes.
Yes, Lordship.
Your Lordship, I beg to mention item 53, Your Lordship. 53, Your Lordship. 2 weeks' time, Your Lordship.
What's the matter about?
Service matter, Your Lordship.
Service benefit.
What kind of service matter?
Yes, Your Lordship.
What kind? Service matter, all right?
Yes, Your Lordship. For approval, Your Lordship. Regularization.
Yes.
My lord, he has been regularized, my lord.
Then what remains?
Basically, my lord, second
What's he
regularization, my lord. His
Only from the department, Your Lordship. But
what do you file affidavit, my lord? We have cleared out that second regularization is not permitted. He wanted regularization as per the cabinet, my lord, 2022. But we have already
Right prior to that.
prior to that, my lord.
Then what is your case? Will dispose it of?
no, Your Lordship.
No.
I'll seek instruction.
Yes, after 1 week on the prayer of MSCP Pajo. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 49, Your Lordship. I am from the council.
Why?
Your Lordship, we have some personal difficulties, Your
Whose
Lordship.
personal difficulty?
The conducting council. That's correct.
No objections, Lordship.
Yes, 2 weeks.
Your Lordship, similar prayer for item number 52, Your Lordship.
52?
Yes, Your Lordship.
Yes. No objection?
No objection, Your Lordship.
Your Lordship.
May please, Your Lordship. Lordship, I beg to mention item number 47, Lordship.
Where the petitioner?
For the petitioner, my lord.
No objection?
No objection.
In this matter, I am for respondent number 6.
You have objection?
No objection.
Is MPC a matter that regarding the reservation?
Reservation, my lord. Out of 2 seats, none were allocated to any SC candidate.
Yes.
Can be taken up next week, my lord.
1 week.
My lord, may I have it after the
After what?
26th? My lord, the learned advocate general is leading this matter and
He appears every day online. 1 week is.
Much obliged.
my lord, next week.
Yes?
I think that next week, Lordship, the AG's son is getting married.
Oh, yes.
So anytime after
I thought
the
it's-
28th.
Okay, after 28th, yes. 29th.
Much obliged.
Highly obliged.
Supplementary list item number 1.
What is this?
My lord, the petitioner's predecessor actually, when he was a Muller, he had filed a title suit on a miss case. The miss case happened to be dismissed and he had gone on appeal to the court of the judge, district council court. There also the case was not allowed. Then he had filed a second appeal, and during the course of the second appeal, the lower court records were called for in 2015. Then the records were sent back from the High Court, but it was missing. The records were not found. And meanwhile, during the proceeding of the second appeal, the district council had enacted one rule, the Khasi Hills Autonomous District Council appointment of
So what do you
chief
want here?
and restoration of that title suit, my
How will
lord.
you come and petition restoration title suit?
The restoration petition
You
is
feel
missing
some-
from the court. That is my grievance.
They're not taking up the matter. You file a 227 application to dismiss this one. How will you have under 226? This prima facie the petition director is by the way of petition seeking directions to issue to the trial. What court is this?
Court of the POs SDCC,
Is Khasi
presiding officer, subordinate district
Khasi
council
Hills
court.
to issue to the subordinate council court for taking up the restoration application filed by the petitioner. Prima facie petition not maintainable as the petitioner can take recourse to
Obliged.
other provisions. Yes.
Wait for
Yes, I've dismissed it.
Item number 2.
May it please your lordship.
Yes.
Lordship, here the petitioner was working as a casual employee, my lord. Thereafter, he was conferred with the status of RCW.
RTW.
Yes. And after he came...
When? You served for 10 years?
Yeah, more than 10 years, my lord. Then he was conferred with the status of RCW by order dated 21/8 of 2023, my lord. Page 22, Annexure 4.
Yes.
After that, he came to know that there was a vacant post available, my lord. 2 vacant posts available before the same office. So he submitted an application
Yes.
on 10/7 of 2024. But this application was not disposed of in his favor, my lord. And thereafter, my lord, instead of disposing of this application, my lord, the 2 said posts, my lord, was intimated to DSC for recruitment, which we came to know by the RTI, my lord, page 27.
Yes.
office peon and chokidar, grade 3 posts, intimated to DSC by TO number such and such, dated 30th 7 of 2024. So these two posts thereafter was advertised, my lord, on 1st August of 2024, page 28. The relevant portion would be at page 30, my lord, or page 31 at serial number 32.
Okay. Yes.
So my grievance is, my lord, that the two posts, my lord, is in contravention to the rules RCW, Meghalaya RCW scheme of 1996, my lord. Because the scheme says that clause 5 of page 37, my lord. This is the scheme.
Yes.
Clause 5 says, my lord, when vacancy in Group D posts arise in any department or office, 50% thereof shall, subject to rules, orders, and the instruction of state government, may from time to time issue, be filled up from amongst the RCW working in the department or office.
Any other RCWs working?
No, my lord.
Who are senior to you?
No, my lord.
I'll have to take instructions on that, your
That
lordship.
is the easy moment. The constitution issue notice. Returnable in 2 weeks. MS in our country. GH present except to
For all the respondents, your
all the
lordship.
respondents. No further notice required. So. It's on so and so for instructions and affidavit.
Well, I've also filed for miscase, my lord, for staying of the
Yes,
advertisement.
2 posts advertised visa.
There's no urgency also, your lordship. This advertisement is dated 24.
Yes, my lord, but of course they have not yet issued any notification, my lord. But
3. Obliged, your lordship.
Yes.
May I please, your lordship? Lordship, this matter pertains to freezing of my bank account, lordship, without any prior information or notice.
Which
lordship.
bank is this?
State Bank of India, lordship, from the Ranipur branch, your lordship.
What's the amount? Dispute amount?
74,000.
74,000. How much money is there in your account now?
74, lordship.
No, in your account, apart from 74, how much money is? What is the total?
The disputed amount is only
No,
74,000.
70 fine. What is the total amount in your bank account now?
Right. From the bank statement, lordship, it's only with the closing balance, it's only 78, lordship.
I'll explain that.
So 74. Wait, relax. 74. That means only 4,000 is there. Even that the frozen account.
Yes,
Where's the bank statement?
in Ranipur branch, your lordship.
Page 10. Page 10, my lord.
Yes, 78,000. Then you take issue. Heard. Your name?
Is this Sama, your lordship?
Yes. Issue notice. Returnable in 2 weeks. Yes. MS OI Bank.
Respondent 1, my lord.
Acceptance on behalf of number 1. No further notice of respondent. Steps to taken to the for number 2 within 3 days. Just after 2 weeks.
Obliged, your lordship.
Daily list item number 1. Daily list item number 1.
Or Yatra. Yes.
May it please the lordship, on the last occasion.
Was it
On the last occasion, my lord had allowed that intervention application with a direction for them to file an affidavit to state whatever is the case. We are yet to receive any as such affidavit.
I'm appearing for respondent number 10, which is the same lordship. I pray for a week's time, lordship, to file our objection, to bring our...
okay, that apart now, with regard to the other matter which is in the PIL, which is referred division bench, what steps have you taken between the PIL petitioner and the CM?
Lordship, instructions have not been forthcoming.
You ask him what instruction, otherwise we'll segregate it for the time being and then you sit across the table. But this matter actually is come up from a different cause of action altogether, and because of the orders division bench we have to take up both of them. So that has created a bit of dislocation in the proceedings. So we would like to, one part at least, to now there's an intervener that further,
Complicates matters.
complicates the matter.
my lord, as far as the intervener is concerned, his case, my lord, appears to be far larger. The scope of his case appears to be far larger than mine. I'm only required to humbly point out, my lord, that the yatra for this year is scheduled for 8th and 9th August, my lord. So
before that, we will have to.
The only step that is required, as far as my limited case is concerned, my lord, is for forming that committee by this honorable court.
Supreme State. Yes, what's the other committee? What's happened? Had the commission reconstituted the committee?
That committee has been. We have forwarded the name for reconstitution of the committee before this honorable court. We have considered that has been set aside by this honorable court.
My lord.
Yes. So.
In fact, there's an order of 10th July last year where Honorable Court had observed that we have given our proposals, and Honorable Court expressed Court's view that the committee will be formed by my lord.
What has not been done, but the whole thing got diluted because of these other things.
These other aspects have come in and sort of diluted the waters.
So for today, affidavits to the intervention application.
Yes. Yes, sir. As far as intervener is concerned, he is required to file.
Are you filing affidavit? You filed affidavit?
No, not yet, madam.
You will not file?
We will file. Because the CM not yet reply in our...
No, that's with regard to your dispute or regarding to the dispute to intervener?
Yeah, intervener not yet file, I will file.
Who's appearing to intervener today?
I not yet received their petition.
Because they have not, as Lordship's direction on the last occasion was for the intervener to file an affidavit. But intervener has not yet, at least no copy has been given to us.
It's been added as respondent number?
11 to 15, if I'm not mistaken.
Oh, he's been added, intervener has been added respondent number?
11, 12, 13, 14 and 15, your lordship.
Intervener?
Yes, as a party respondent.
There are quite a few of them, my lord.
Quite a few
interveners?
Yes, yes.
Where's the...
That order was passed in miss case number 115/2026.
Miss case for him. Of course, that line. Not shooting a petition. Yes. The interveners who have since been implemented as respondents 11 to 15 were required to file the affidavits to allow the other parties to put in their objections. However, none appears on their behalf, nor any affidavit filed. So, in interest of justice matters will stand adjourned for 2 weeks to allow for the affidavit stop. Mr. S. Jindal, on another limb of the matter, has submitted to the committee to be chaired by Deputy Commissioner is yet to be finalized.
Yes.
With regard to the
conduct of yatra.
Conduct of the yatra. The said issue also will be taken up on the next date. With regard to the directions of the division bench for settlement dispute between the PL petitioner and the respondent number 10. The parties submit that they have not received any further instructions. They are directed to come with instructions, respondent 10, especially on the next date. Let's figure out what to do. Yes, let's after 2 weeks. Before the order here.
2.
May please lodge.
Yes.
Lodger, I prefer some more time to file my affidavit.
Not filing affidavit.
My lord, we've already drawn the affidavit and sent to the department lodger, but then due to some new information we required, we had to include. Lodger, I require.
That was on 15/5. I give 2 weeks time now. It's nearly a month.
I prefer a few days time, lord.
Few days can mean anything.
Or 1 week's time, lord.
For 5 to 7 only.
Yes, my lord.
What about the other respondents? Not necessary. You're appearing for the other respondents.
Lordship will examine after they file the affidavit.
I can't hear you.
Lordship, we will examine the affidavit on this.
We'll examine whose affidavit? 5 to 7?
Yes, Lordship.
Yes, Mr. H. Karmanlang, today we need a prayer for filing of affidavit on behalf of, for further time to file affidavits. Praise the Lord, it's up to 2 weeks. Yes.
Highly obliged, my lord.
3.
Section.
We've already filed our application for summoning of the additional witness on the 11th of May 2026.
No objection, Your Lordship. Let him summon.
Yes. Which witness you want to re-examine? Re-examination additional.
No additional witness, my lord. So
You already
it's not
finished
a
with whom? We
re-examination.
finished with the.
We have finished with the stamp reporter, my lords, but as far as the stamp reporter had named the assistant registrar filing, my lords, as the person concerned who has checked the petition.
Where's Mr. Deb?
It's on next, Your Lordship, I think.
Yes?
Let us witness be summoned within 1 week, Your Lordship.
I have to order sheet in this case. This
Because the stamp reporter in her deposition had named Shri Democratis Marbani and assistant registrar in charge filing as the relevant person who has checked the election petition. Accordingly, my lords, this application was filed for summoning of additional witness, i.e. Democratis
Can I
Marbani.
take down this case number? Miss EP bracket case 1 2026 election petition number 1. This is an application for on behalf of the respondent.
Yes, ma'am.
For examination of additional witness, namely the Democratic Marbanyang as a registrar of this court. Ms. A.S. Pandey submits that this has been necessitated due to the fact that when the stamp reporter was examined on
18th March 2026.
On 18th
Within 1 week,
March
Your Lordship.
2026, in her deposition, she had named the Democratus Marbanyang as a bracket assistant registrar in charge of filing, who had checked the petition.
Yes.
With regard to compliance with the compliance in terms of Section 80 of the Represent People's Act 951. Stop.
81.
Yes.
Within 1 week, Your Lordship. J. Sutiang, Your Lordship. I'm appearing on behalf of STEP.
1 week.
Is appearing for the election petitioner. I have no objection to the the miss case, the misapplication. Stop. Accordingly, let the Democratus Marbanyang be. He'll be witness number.
Official.
Yes.
He will be an official witness.
Good morning. The assistant registrar report to be summoned as official witness to tender deposition on.
Within 1 week.
Because first week, I am requesting because first week of July. There's some
No, Your Lordship. Within 1 week, or tomorrow or Friday or so, Your Lordship.
Tomorrow?
Within
it will be difficult, Milos, for me to be physically there.
Yes.
Within 1 week. Within 1 week, Your Lordship. Yes.
First week of July, Milos.
Because they have some problems.
Yes,
first week July. Where's Mr. Deb?
Yes.
But within 1 week only, Lordship, for someone of that witness.
The process will take some time. Because
they have to issue summons also, yes.
Yes.
Yes. Yes, stop respondent to issue necessary summons to fund registry for for necessary process. Stop. Next, list the matter on. We have with regard to the date, Mr. J. Shu Chang has prayed that the matter is after the evidence be recorded after the evidence be taken up after 1 week. But however, Mr. A.S. Pandey, due to pressing personal commitments, prays that the matter be taken up the first week of July. Now we on. Today is the 10th. He will take up first week of July. Yeah, we'll fix it on Wednesday, 1st July.
17 or 17 or...
Yes, this matter on 4th of July as a fixed item. Recording the position of the newly added witness. Miss K stands dispose of his.
Obliged.
What's it for today?
Instructions, Your Lordship.
My lord, we did not receive any application saying that they want to revise the further revision of the environment compensation. We have not received, and we do. We told my lord we will not be revising also.
Up to 96. Whiskey 96.
96.
As per my instructions, we have submitted the application before the member secretary.
We have not received it, my
So
lord.
I pray for.
I have
How is that
verified.
possible? Have you,
My lord does not receive. My lord, they don't even show what is the draft letter. The draft letter doesn't have no signature, no receipt.
this was
copy.
filed, this Miss K was filed by you, or no?
Yes, my lord, but they have sent a second.
This is 96 was filed by whom?
By me, my lord. My lord, after this
I'll
they
place
said.
a fresh representation, Your Lordship, and let the matter
One
be
second.
deferred for 2 weeks.
This application has been filed and yes, Miss Case number 96, MSOI Bank, which submits that on verification, she has been informed that no application is pending for review of the revised environmental compensation prayer made by the petitioner.
I may be allowed to place a fresh representation.
Yes. Mr. Pasantil is therefore directed. Oh no, this the Constitution is therefore directed to instruct the petitioners to put in a fresh application within 1 week. Yes. Just after.
I'll reply to it, my lord.
Yes, just after. Yes, 1 week. Yes.
My Miss Case 17 of 2026 remains pending. Let it be considered on the next date. I'm grateful.
This is a matter after 2 weeks. Yes.
Five.
My lord, 5 and 6, Learned Counsel had filed the affidavit and I have filed the rejoinder also. Matters may be posted for hearing.
Yes, the parties submitted claims are complete. This is a matter for hearing.
5 and 6.
5 and 6.
All right.
7.
May it please, Your Lordship.
Yes.
This is the case, my lord, regarding appointment of the arbitrator, my lord. On last occasion, Lordship has sought instructions, my lord, from my client whether, my lord, they have the consent or not, my lord. I have been informed, my lord, but what they have stated, my lord, in the letter, my lord, that because of the qualifications as required under the arbitration section, condition 70 of the arbitration, my lord, they are unable to accord their consent, my lord. The engineering degree is a mandatory.
How much cost you'll pay then for wasting the court's time and for agreeing to the first proposal?
My lord, actually, my lord, I have stated in my miss case, my lord, because.
How much cost will you pay? Firstly, asking a review of an order under Judicial Part Section 11, which is not permissible.
My lord,
and then number 2 is that it's on your consent that after you're appointed.
My lord, what is
now,
it?
number 3, last time and after all that has happened, you have come now to say that the operator is not competent to.
My lord,
then,
what the miss case which you have
so you have
filed,
to pay some cost.
My lord, miss case has been filed, my lord, because it was in virtual, my lord. My junior colleague, my lord, he could not.
That excuse is not acceptable. How much cost are you willing to pay?
Lord, this is my lord. Virtually, my lord, he appeared. He could not follow, my lord.
About what happened. We'll accept all the content. He appeared virtually. Whatever the consent was made. Now, upon was taken. Consent was received from the arbitrator also, which has caused a great embarrassment to everybody.
Yes, my lord.
Since he's retired Chief Justice, how much cost you will pay to Legal Service Authority?
My lord, since
50,000
or
1 lakh.
Not be possible for the
yes.
May not be possible for the council, my lord.
Not council. On your company, SBG Infracon.
Because they have my junior counsel, my lord. They have
no.
He has also not received the consent.
You have to take responsibility. Yes. Where's Dr. Mujika?
Lordship, he's on legs. Lordship, I'm praying
We'll
for this
some
matter.
time.
Yes, my lord.
Oh, he's come.
Yes.
Yes. Will review the order even though it's not permissible in law, but he'll pay a cost.
Again, it will come back to because they gave consent well on that day.
For the consent, he's on a mercy petition saying that it was a
Because on that day, my lord, he sought for time for filing rejoinder, my lord. It is apparent from the order, my lord. And my lord, he could not follow.
Okay, we'll review it. You pass, even though we'll pass orders, okay, allowing you to.
Yes, my lord.
But then recording the early order. But the thing is that you have to pay costs. You wasted the court's time.
My lord.
Yes.
Small amount, my lord, because ultimately, my lord, the client is also not given the consent as per their letter, my lord. Apparently, it is a fact apparent, my
Then you
lord.
figure it out among yourselves how you're conducting your cases. Is the court to advise?
So, value contract.
Mr. Alam?
Yes, my lord. I am also embarrassed, my lord, but
is the court to advise how lawyers to conduct the.
It's a 40 crore contract, my lord.
40 crore contract?
No, my lord, claim is something would be different, my lord, because the contract doesn't
It is
mean that, my lord.
1% of the contract value. 1% of the contract value.
1% of the contract. Yeah, that's fair enough, I think.
My lord.
For legal aid, yes. See, you have to pay for mistakes made. You asking for prayer that's not sustainable or maintainable. Take down Mrs. Case arbitration P number 1/2026. This is an application for modification and alteration of the order dated 16/4/2026, passed by this court in arbitration petition number 10 of 2025. The prayer for modification has been made in view of the fact that an arbitrator, as the retired Chief Justice, on the consent of the parties, had been suggested for appointment arbitrator. Subsequently, the consent of the retired Chief Justice was obtained to conduct the proceedings. Stop. By the present this case, however, it has been submitted that condition 70 of the general conditions of contract requires that the said arbitrator must be having an engineering degree. So, though this clause 70 has been amended to exclude serving officers, Mr. G. Alam, counsel for the applicant, has submitted that it is a mandatory clause. Such praise that the order be recalled and the new arbitrator be appointed to conduct the proceedings. Stop. If Dr. N. Musicala JCI has submitted that a review of an order passed under section
11.
under application file under section 11(6) Archival Act is not maintainable, and further at the time of appointment of retired Chief Justice, the consent of the counsel appearing for the petition had also been obtained. He further submits that was other submission that assistance of last time the assistance of engineer can be taken.
Yes.
He submits that assistance of an engineer as a consultant in proceedings can also be availed of, and therefore the application deserves no consideration. You see that, no?
Yes.
Yes.
And another aspect, my lord, is an identical matter. With Justice Sanjeev Banerjee was appointed, that matter is pending for Supreme Court on the same ground, whether clause 70 is mandatory or not.
He also had brought notice of the court that another similar matter with regard to the same clause 70 and eligibility of the arbitrator, the matter is pending consideration before the Honorable Supreme Court. So the last time will come, therefore that will be rejected. So,
the review petition number 22 of 25. This order is here.
This is? The order was dismissed by this court.
Yes, review was dismissed and they have gone. And this is precisely this is the question, my lord. Whether clause 70 still requires mandates engineer or doesn't, my lord. First one.
You know the judge, you've seen the judgment?
No, I'm not one from my lord.
SLP number is so since SLP is pending, it may not be.
Yes, it is pending.
Yes, how can you review the order?
My lord, SLP is pending, my lord, still yet, my lord.
Then?
But my lord, in a case, my lord, here, my lord, there is a case, my lord.
Yes, your own doing.
My lord,
you dug your own grave.
My lord, this is a case, my lord, where my lord, my respectful submission will be, my lord, because since consent has been obtained, my lord, as per provision of 12, 11, 8, my lord.
Consent only be obtained from the arbitrator also.
Yes, my lord. And my lord, 11,
it's not
8.
the correct form. That's what you mean to say. Are you going to technicalities now?
No, my lord. I'm not on that, my lord. I am just on the provision, my lord.
The provision is fine. We obtain a consent of arbitrator. Now you mean to say that the consent was given in the correct form? That he's no conflict of interest. You mean that form? That it should come in that form, the consent. When you file an application, you challenge that.
No,
we'll dismiss the application now.
No, my lord. I'm just submitting the provision, my lord.
So you're making a submission. You're saying that the consent also, that means it's a incompetent consent. That's your submission. It will not amount to a consent or a valid appointment arbitrator. Is that your argument? That's argument you're making, right?
No, I'm not. I'm just.
So maybe I misunderstood, but is that argument you're making that even the consent that this court will not be cancelled, recalled order because that consent which is received doesn't amount to a valid consent? Is that your submission?
No,
as
consent is no. I'm not on consent, my lord. Consent is valid, my lord.
Then
what I'm submitting, my lord, the provision says, my lord, after receiving the consent, my lord,
you should give the form, the proper format.
Yeah,
so you're saying on the technicality also this court has to review the order.
No.
Then
I'm not. I'm just submitting, my lord. Appointment is confirmed only subject. That is the provision says, my lord. I'm only stating this, my lord. My submission is this only, my lord. I'm not submitting, my lord.
But it's fine. Modification. This is a review.
Yes.
We'll take a. Can we take a divergent view?
Yes.
That's what. If this order is placed in that matter, they'll create some complication. Or we can wait for the decision in SLP, my lord.
Yes. From the last line, reject the application. As such, he submits that this application stage should be rejected. So, now full and counsel of the parties, and though the counsel of petition has made a passionate submission with regard to review the order, review or recall of the order, in view of the fact that the matter is pending consideration, in view of the matter on the same point pending consideration is SLP before the Supreme Court. This is a matter of 6 weeks, so within the outcome. Who made it's your own doing?
My lord.
Yes.
What I am submitting, my lord.
That will not be proper.
After 6 weeks.
Still be pending.
Yes.
Oblige, my lord.
Yes.
8.
But please, Lordship, I'm praying for some more
Is the
time
pension
to find.
matter?
Yes, that.
Pension matter?
Yes.
Why was not settled mediation? You appear, both of you.
We have come, but all the parties present, but then they will not able to compromise.
Why they couldn't agree? Pension matter. You are the second wife.
I'm the first wife.
We are second wife.
Yes, second wife.
Where's the mediation report? Yes. These matters should be settled amicably, you know. You want to file a joinder?
Yes, Lordship, I filed the joinder.
Yes, this matter has been returned back from. Oh no, only thing. One thought, no, I'm not sure. Mr. PD Sama to replace for further 2 weeks time file.
Lordship. Much less, Lordship.
9.
Please, Lordship. Lordship, we require some more time, Lordship.
Why?
Lordship, there are some further instruction required.
What about the
Lordship.
instruction? This is matters since when you've taken time for adequate?
4 times, Lordship.
Yes, Lordship. They've been implemented since.
Madam, for respondent number 3 in this matter, I will not file our.
Okay, Mr. Kriam, you won't file. You won't file. That means only
4 and 5.
4 and 5. Mr. M. Ahmed, today on person number 2.
Your Lordship.
You are number 2. Mr. S. Kriam on behalf of
Kindly
number
allow
2.
3 weeks, Your Lordship.
And Mr. M. Ahmed, behalf of respondent number 3. Submit that no efforts be forthcoming from the respondent staff. Now, however, S. Lalu, counsel for the response 4 and 5, praise for
3 weeks, Your Lordship.
why 3 weeks? Not for the 3 weeks time for activity.
Much obliged.
in the next matter. Lordship is connected matter, Lordship.
Yes.
It has been tagged together, Your Lordship. Connected matter, Your Lordship. Arising from the same title suit, Your Lordship.
Who's for the respondents?
For the respondent number 1, my lord, in this matter.
Who's FL Dakhar for 2?
I'm there for 2, Lordship.
You need to file, want to file affidavit? No.
No.
Yes, Mr. Kharkran.
Lordship, I'll just take instruction, Lordship.
List is matters together with so and so. Parties to obtain instructions as whether necessary. Respondent number 2 to obtain instructions whether affidavit be necessary. Yeah.
11.
I'll oblige, Your Lordship.
Lordship, I just received the affidavit this morning, Your Lordship. I'm praying for 1 week time to go through the affidavit, and if necessary, I'll
The
file.
one was
my
suspended?
return. Yes.
Is it suspension? 4 and 5 is appearing 4 and 5.
Appearing for the Nehu, Your Lordship.
S. Deb for 6.
Yes, yes.
1, 2, 3,
perform
Nehu. 4 and 5 is whom?
Mr. Deb. Mr. Deb.
No, 4 and 5 is not Deb. 6 is Deb.
They have not yet entered appearance, Your
not
Lordship.
yet, Your Lordship.
Not yet entered appearance, Your Lordship.
4 and 5, Professor Maulong, Professor Moses. How much time you require?
Your Lordship, I'll file my affidavit during the course of the day.
MS S. Dhar. Correspondence 1, 2, and 3. Submits affidavit will be filed in the course of the day. None. Where's Miss S. Deb? None appears for respondents. Miss for 6 stop. With regard to respondents 4 and 5.
Your Lordship.
Though they have been served, this
Mr. Deb is on leg, Your Lordship.
appearable today. You're filing affidavit? No. Yes or no?
No, Your Lordship. As per the order, last occasion, Your Lordship, he has submitted that he has filed his affidavit.
You only filed. You're not aware.
I didn't receive any instruction, Your Lordship.
How's the court to proceed then if nobody has any instructions?
Can you check the last order, Your Lordship?
Second. No, not fine. Yes, from the MSS Dar sub 1, 2, 3 submits after to find the course of the day. Stop. With regard to points 4 and 5, though they have been served, there is still no appearance today. Accordingly, the matter shall proceed ex parte against point 4 and 5. So, next paragraph, with regard to number 6, Ms. Alamari has no instructions as to whether an effort will be necessary or not. Just after 2 weeks for further orders. For the joint, have any?
12.
In this matter, Your Lordship, I've already filed my affidavit, Your Lordship.
Yes. You want to file a joinder? No.
Yes, Your Lordship, I would like to file a rejoinder.
What is the case about?
Lordship, it is about the student was not allowed to appear in the 5th semester examination. Only one paper.
What
Family law.
reason? You wrote representation through the Ministry of Education also?
Pardon, Lordship?
You wrote representation in the Ministry of Education also?
Yes, yes.
What kind of student are you?
Lordship, he's trying his best to appear for the 5th semester examination, but he's not getting the
He's
opportunities.
busy doing other things than
Lordship, we are just concerned about the examination, nothing else. We just want to appear in the exam and clear our result.
As per it, 2 weeks time out for joinder. List thereafter.
May it please, Lordship. Your Lordship, I beg to make a recall on the item 48, Lordship, as there was an interim order in this matter, Lordship. 48, Your Lordship. I've mentioned earlier, Your Lordship.
Don't mention it now. Can't mention in the middle of proceedings.
I've mentioned it, Your Lordship, earlier, as there was an
You
interim.
mention later, after, before the court rises.
Oblige, Your Lordship.
Don't make this mistake. Yes.
May I be Lordship? Item number 13 and 14, my lord, both are promotion matter, my lord. Notice was issued on 17th December 2025, my lord.
May it please, Your Lordship. Your Lordship, we're required to file an affidavit.
Yes, you're required to file.
So we're
Last time you prayed.
2 weeks' time, Lordship, to file an affidavit.
Who's it?
Persons are suffering from immune surveillance, my lord. Actually, rule is very clear, my lord.
The HIV positive?
Yes, my lord.
Yes,
They
anyway,
can't be
2 weeks time to file. Further 2 weeks
My
time
lord.
by affidavit.
Highly obliged.
My lord.
15.
Your lordship.
15.
Please, Your Lordship. Lordship, this is an application, my lord, praying for leave of this honorable court to file the accompanying review petition, my lord.
Lordship, I have filed. We have filed the objection, my lord. First instance, this application is not maintainable because I have stated in my petition that they are the earlier, since this petition was between the respondent, Tinda and Kenola. That's since from.
Where's the order? Seeking review?
It's in the accompanying review petition, my lord.
You're not parties there?
No, I was not a
Why
party.
are you seeking to implead to relieve fund?
Because the matter, my lord, in respect of Apple matter,
Just give the. You're a Chra or you're a.
Yes, I'm Chra, my lord.
No. Yes. Where's the order, Mr.
Page 34, my lord. The matter was disposed of on the basis of the agreement executed by the respondents, my lord.
So we already divided the money?
Not yet, my lord. Not yet, my lord.
No, my lord.
Not yet, my lord.
You were for 4 and 5 in the earlier petition?
Yes, sir.
That means you are Itarsan Sangma?
No, I'm Tinda.
Tinda. Tinda. Then you Itarsan Sangma?
Itarsan Sangma.
And Kenola Marak?
Kenola Marak.
Yes. Who are you then?
I'm the staff that Rangthongre Akhang, my lord. There is an application.
Let's see on what basis he's filing the. Let's see. You place your petition. You place your case, rather.
Here, what has happened, my lord? After the demise of the earlier of the Nukma, my lord, they have submitted a agreement, Tinda, that they will no longer hold the post of the Nokma. That agreement is there, my lord. I've enclosed it here, page 20. So after that, we filed an application way back in the year 2025 before the Deputy CM, my lord. The matter is still pending adjudication, my lord. That had not been disclosed before.
Just want to clarify no, Your Lordship, that copy which he is referring has not been supplied to us. How? Because he has given only the
no, that has not been even registered, my lord.
Then? So he is pleading from the place which we have not. He have not been never
Now
supplied.
I am before this honourable court seeking for the leave of this honourable court to file this review.
He has to make a submission to first application.
In the miscase, show the settlement. Where's the agreement? That shows. See, you have to first establish whether you have any locus at all to ask for leave to file the review. What is the locus? See.
Lordship, I have enclosed in my complaint.
Agreement reached between these parties. Now, what's the locus to say that that is wrong? Where have you said that? It's just said that is a third party.
There is no mention in the petition, Lord.
No, para 3, my lord. Para 3. So the case which has been registered as GHC.
Where is the material to show that?
I have not enclosed it here, my lord. I have enclosed in the accompanying.
Miscase review number 2, 2026. Stop Mr. AG Movement. And sub. Major Movement Council Petitioner. Stop has submitted that the prayer has been sought in view of the fact that the applicant is a chra of the Chambugong Mahari of Rangthang Sora Akeng and should have been necessary party but was not completed. Stop. The prayer submits that a case has been registered as GHDC capital -REV/04EC of 2025, which shows that there is a dispute in the Nokamaship of the said Aking, which is pending adjudication before the Deputy Chief Executive Member, which is not disclosed before this court. Stop. Mr. P.T. Sangma and Mr.
James.
Yes, they have however raised objections and submitted that the applicant has not brought any materials on record to substantiate these facts. So this court examined the application and notes that the submissions of the opposite parties are correct. There's nothing to be annexed to the miscase to show as to the pendency of a matter before the district council, before the executive committee district council, before the in charge revenue council, or any other supplementary proceedings are pending. This is the matter, the miscase being incompetent is rejected at this stage. However, liberty to the applicant to file a fresh if so advised. Yes.
16.
May it please your lordship.
Yes.
My lord, in item number 16 to 22, my lord, I appear for both the contemners. My affidavits are ready in all the cases, my lord. There is a slight technical defect which has made it necessary for me to re-notarize the last page of my affidavit. So, subject to your lordship's kind leave, if these matters are taken up on 23rd, I'll be ready with the affidavits by then.
How much time? When are you going to file it? That's more material. When are you going to file it? Today?
My lord, I was ready to file today, but
how much time did it take? 1 week?
1 week, my lord.
Yes, Mr. You are Mr.
N. Barwa, N.K. Barwa.
Mr. N.K.
Barwa. B.R.U.
N. Barwa, yes.
N. Barwa.
Appearing for the respondents, some to do some technicality, some technical fault. The offence going to be filed today. He prays funds allowed a week for the time to file the same. Yes, list thereafter and so on. So you take the date in the court master. Yes.
23.
Lordship, in this contempt matter, we have received instructions, Your Lordship.
What the instructions?
Instructions are that it's under process. The gratuity has to be released as per the division court's order, Your Lordship.
Any communications?
Yes, we have received the communication, Your Lordship. If Your Lordship wishes, we can bring it on record by way of an affidavit, Your Lordship. This is an order dated 28th April.
The order is in the stage of compliance.
Yes, Your Lordship.
He prays for And allowed 1 week's time to file
1 week's
affidavit.
time. Like,
24.
this is it.
My lord, item number 24 to 28, my lord. A similar matter, my lord, prayer for disability lump sum, but affidavit in opposition in item number 25, 27 and 28 has not yet filed, my lord.
25, only 26, 27, 28, 29, 30.
25, 27 and 28, my lord. Affidavit in opposition has not yet filed, my lord.
No, now here last recorded is what is WPC number 26?
28,
Number 26.
26 affidavit in opposition has filed, my lord.
There will be item number 24. my lord. That's item number 24 in today's list. my lord. 24 and 26 we have filed. my lord.
Yes.
24 you filed, 26 you filed. my lord. 25, 27,
26 you filed?
Yes, ma'am.
26 you filed, 24, 24. 24, item 24 you filed?
Yes, my lord.
Then?
26 also filed.
Item 26, 28, then
The remaining are pending, my lord.
up to 32
Up to 28, my lord.
with the disability.
My lord. 29, 30, they are different matters, my lord. Here also we are yet to file affidavit.
So, can I get joint orders, any? Mr. Dr. Mbuzika submits that in number 26 and 28 absence been filed. Yes. He prays for and allowed 2 weeks for a time to file after the remaining 3 petitions.
But here what happened, my lord, similar matters, 30, 40 matters are pending, my lord, and individual affidavits take a lot of time, my lord.
Why don't you then you put a chart or something?
But that's what I was proposing, my lord, because there are other matters listed on different dates, my lord.
That is,
We'll make an attempt to
further also submitted that on the same subject matter, other representations are pending. He prays that
prepare a chart,
be allowed to
instead of filing affidavit.
Submit a chart instead of filing affidavit, so the matters can be consolidated.
Yes,
for conveniences for the court. Yes,
my lord.
Please allow, yes,
my lord. My lord, item number 29 to 32, my lord. The matter are 29 to 32, my lord.
Yes.
The matters pertains to non-communication of ACR, my lord. The affidavit in opposition in these matter also pending, my lord.
29 to 32.
I can find.
The new matters. But here also I will try to prepare a chart, which can be disposed on the basis of chart itself.
What chart for ECR? Non-communicated ECR?
Which is non-communicated. Can we dispose of common order also if chart is available?
Yes, in these matters, the 31, 32, 334, WC, number 31, 32, Mr. N. Muzika also prayed out to bring as they are similar to place for the chart. The matters can be disposed of jointly. The same objected to by Mr. V. Kumar, list after 2 weeks. Yes.
My lord, deep your lordship.
3 weeks. Yes.
My lord, deep your lordship.
Yes.
33.
They also for affidavit, but I'm taking some time. This is a different matter.
Yes, where's Mr. Nompure? Oh, he's here.
It's for affidavits, lordship.
26 matter. You should refer to National Lok Adalat. How? Anyway, as prayed for the 2 weeks time allowed for affidavit. Yes.
This is 30.
34.
Lordship, here the affidavit has been prepared, but however, once it is approved, we'll file it.
Yes?
The affidavit is ready, my lord, but once it is approved, we'll file it.
Approved by whom?
By the CE, my lord.
What's the matter about?
It's a pension matter, your lordship.
when did the person retire?
In the year 2020, Your Lordship.
Never got any pension since then?
No, no Lordship. Expired now. Now it's presented by the legal guardian, Shivani Biswa.
Are you appearing for? Respond number?
Where was the statement?
It's for the state.
You filed it within 1 week?
1 week, yes.
Yes, give Bhattaji please for 1 week's time. Expected next day, right? I should be on board, yes.
35.
Yes.
Of 19 September 22. Affidavit is awaited, man.
3 weeks time.
3 weeks for a time spray allowed. Yes. This also. 36?
36 also.
36 also, my lord, non-communication ACR, but affidavit has not yet filed, my lord. 37, 38 and...
All non-communication ACR?
No, but 37 and 38 can be clubbed together with those 5 matters, my lord.
Which is disability pension?
These are disability pension.
My lord.
Yes, it is submitted by the council of the parties that item 37, 38 can be clubbed together with WPC 26.
Yes. 26 of 2026.
Yes. As a subject, as the same subject matter issue. Prayers allowed, yes. This together on the next day, 37 and 36. The ECR will club together with the other cases.
It can be, my lord.
This is slightly different, my lord. I'll file a separate affidavit.
In 36, but for 2 weeks further time has been allowed for affidavit. 39?
39 is a contempt, my lord.
39 is contempt case.
39 and 40.
Of for category ACP and MECP benefit has not yet granted, my lord.
Have you filed affidavit?
We filed affidavit, my lord, of compliance. They are saying that they want to distinguish, and a submission was made that Mr. Pathak will argue in person when he's here physically.
After the first week of June. Where's Mr. Pathak?
He is on legs, my lord.
We'll post it for hearing then.
Yes.
My lord.
This is matter for hearing. Yes, on yes.
Along with item number 40, my lord. 40 is also similar matter, my lord.
Along with 40, yes. 40 is hearing this. Yes. 2 weeks.
My lord.
Right.
My lord. Keep your lordship.
Yes.
Hearing. Supplementary list 4.
Please, Your Lordship, I beg to recall item 48, Your Lordship, which I've mentioned earlier, Lordship. In the master, there's an interim order, Your Lordship. Highly obliged, Lordship.
Yes.
Please, madam. That's the only thing I was submitting stated for yesterday was that as per the 24th April order, the respondents had to take instructions on the averments in 10th April letter, wherein 19th February 26 interim order of Sikkim High Court has been referred to for the opening of sealed cover, whereas a judgment passed in November 25 has not been referred to.
But I seek apology. There's a slight difficulty because one matter in TV is to be called out, my lord. It can be, but I can start. I can start, my lord. But
after some time,
but one criminal appeal is going on. The matter was called out, my lord. By the time I reached, next matter was called out.
After some time, then you go, you will come back. Yes.
But I'll wait, my lord.
Yes, of course. We'll take it up. After some time, we'll take up other matters.
42.
No problem, my lord.
42.
But this is a matter pertains to release of the basic salary.
That you have to manage the committee, have to pay. What will do this matter? There's no money. They say there's no money.
But in this case, my humble submission before your lordship that since as per the direction of this honorable court, the basic salary and the arrear has already been released to us, But the direction of this Honorable Court, the excess amount which is given to us has to be recovered from the resources of the managing committee. But our only allegation is that that amount has been deducted directly from our salary. That cannot be done. That is my case, my lord.
Your Lordship, that is not the case, Your Lordship. The money is supposed to be deducted from the managing committee. It's the managing committee that's not releasing that amount to them.
So that's why they're deducting from the salary which they are
Yes,
paying.
Your Lordship. So the managing committee is supposed to pay that amount, Your Lordship.
That
is. We are not deducting from them
with a
directly.
physical problem in the way of like physical whatever. In the sense, it's not a legal problem.
Yes.
It's just that the orders of the court are there.
Your Lordship.
Then that money should be taken from managing committee from their resources.
Your Lordship.
They say they don't have any resources.
Yes.
That's the only thing.
Your Lordship, as
so
far as the
what
state
do you
is
all suggest
concerned,
the
we
way
are complying
forward?
with the directions
Yes.
of the court. Your Lordship, as far as the state is concerned, we are complying with the
Even, my lord,
directions of
the affidavit filed by the government, where also they could not show that the extra amount has been given by the government to the managing committee.
Yes.
But extra ground which has been given to the managing committee, they could not show in their affidavit also. In their affidavit, they said that there is no such resources, no such sources of the income of the managing committee. In their affidavit. And I think, my lord, the Honorable Court has presumed the matter that the managing committee has the extra resources and extra grant has been given by the government. That's why, my lord, that direction has come up.
Yes, you see, this direction is page 69, correct?
Yes, my lord.
Direction is followed. As such, this appeal dismissed and modification in order to affect state government and recovered amount is spent in paying a minimum maximum.
For the resources of the managing committee and or of the institution in question, the time frame provided by the so and so has already been expired, that it is extended. And they have been deducted from our salary directly. The last deduction made is at page 125, my lord, where the order, my lord, can see the under the authority conveyed by it, order number so and so dated Shillong so and so, Shillong, the undersigned is hereby release the sum of rupees so and so, only being the salary of the existing science teacher.
Page 1?
Page 125, my lord. That is the last deduction made. Thereafter, my lord, we have approached before this Honorable Court and this court has passed an interim order and now the deduction is stopped.
Your Lordship, if I can take you to the column, Your Lordship, the second last column, it says the amount to be deducted, less amount is to be paid by the managing committee. So, Your Lordship, that...
1 second, I'm just going to which one, please. Yes, amount to be deducted, less amount to be paid by SMC.
Yes.
So they were to pay this much.
Yes.
What they have deducted by the state, right?
Yes, by the state.
But then
Your Lordship, this amount is to be paid by the managing committee.
Then how are you going to pay?
No other resources.
You sell a school.
They have to sell.
They have to sell a school.
No other resources.
And if you sell a school, then your job will go.
Yes, my lord, job will also go.
Given not the party in the appeal, not in the petition also.
Then why didn't you file
They should
for
have come
review at that
forward,
time?
Your Lordship.
That can not.
You're not made party at all.
No, my lord. In the writ petition as well as the writ appeal, my lord, the managing committee was not the party.
What was you or the petitioners?
No, my lord. In the writ appeal, the petitioners are similarly situated person.
Petitioners writ petition.
My lord.
Who were the petitioners writ petition?
In that writ petition, my lord, some similarly situated person. They are also the science teacher of the ad hoc schools. So they have filed this writ petition, then went to the division bench and division then passed an order. Then we have filed a writ petition before this Honorable Court seeking the similar direction as has already been given by this Honorable Court. Accordingly, the direction has been given in our case also.
Where's the order?
My lord, this order is two writ petition has filed. My lord, one is page 71. Sorry, my lord, so not 71. Page 70. Yes, page 71, my lord.
Yeah.
By way of this present petition filed under section so and so, the petitioner have sought that in spite of the judgment of so and so, the passed in the writ appeal number so and so granting basic pay of science teacher of the ad hoc aided secondary school, the petitioner have not granted the benefit of this judgment to the extent of the arrears. That is second writ petition. Earlier writ petition direction given to consider our representation. Then learned counsel of the petitioner submit that they had filed a representation dated so and so, but the same has not yet been considered by the respondent number 2. Therefore, it was prayed that a time-bound direction may be issued to the respondent to decide the same. After passing the writ petition of the hearing, learned counsel of the writ petition is disposed of by writing the respondent number 2 to take a decision on the representation dated so and so filed by the writ petitioner after reporting opportunity hearing to them and pass speaking order within 2 months from the date of presentation of the certified copy of this order to respondent number 2 in accordance with law. Thereafter, my lord, the arrear salary has been released to the petitioner.
And then the order annexure 5. This
Yes.
last one, 22.
Then payment has been released is at page 81. The arrear salary.
So the entire process was complete for disbursing the amount, but after disbursing, it was taken back.
Yes, yes. The meaning of given the disbursing of the arrear
One
salary.
hand giving, one hand taking.
Yes, one hand given and one hand taken.
Very smart. Yes. And many committees.
In the ballot, interestingly, in the next item, the person who has already received the arrear salary already retired, and the deduction has been made by the subsequent teacher, who even not receive a single
was
coin.
not even alive at that time.
Yes.
As a teacher.
Since my lord, in the earlier your lordship has already given a observation in the order dated 18/11/2025 to take an instruction to indicate the taken step by the expert respondents to solve the matter, my lord. But till that nothing has been done. Since my lord, the state can do that, my lord, since a welfare state. (18/11/2025).
Yes. Can you write out the amount?
Your Lordship, I'll have to take
So
instructions.
the thing is that
on
yes, you take instructions.
But Your Lordship, as per this last order also, which my learned senior is referring to, we had a meeting with the department, Your Lordship. They have
There's
stated
earlier order
that they are
4425.
complying with the directions of the division bench, Your Lordship. If Your Lordship permits, we can have another meeting with the department, Your Lordship.
You see the order dated, it's very detailed, 4/4/25. That's the order with you. 4/4/25.
Yes. But in fact, my lord, in the division bench, this honorable court has directed to recover the amount from the managing.
Yes, that is very clear.
That is very clear.
So you made a prayer to the state to.
Yes.
Yes, we have written a letter after receiving the copy of the order.
Of this 4/4/25.
No, my lord. When we received a copy of the judgment of the appeal, then we have written a letter to the government that we are not able to pay the amount.
Then?
And there is no reply from the government.
This is reach a stalemate. We can't. What direction can a court give also? How will your second petitioner, the other petition, recover the amount? Already, how much deducted already?
Already
the other petition?
deducted total release 3,59,600 and already deducted 1,13,300
From the but he's the fresh petitioner is saying he was not in service that time, deducted from his salary.
Yes, in the next state petition, item 43. And we have filed, at the time of deduction, we have filed a representation before the authority, but authority is sitting over.
Filed by the respondent number. You're paying for respondent number MS Begum for
Z Begum.
Z Begum.
9 to 22.
There are only 28 students studying class 9, 54 class 10.
Yes.
If the school has to pay, what is the entire amount involved? What is the entire amount involved?
3,59,000.
That's all.
That's
the school has to pay.
Yes, from 2007 to 2016. That is the area amount. Because the 11,000 they have continuously paid, and the basic pay was 14,100. So the difference of 3,100. That is the area salary. That is the only amount.
So what about the other schools? This is only Mahendraganj.
Only one school.
What about this other schools, Kalegaon and this and that?
No, they have
No, but the additional affidavit filed by the government where
It's an affidavit, additional affidavit, Your Lordship,
Yeah.
They have given the detail of each and every
of all the schools.
You're paying for all the schools.
9 to 23. Yes, ma'am.
All the schools don't have money.
yes, well, as per the additional affidavit filed by the government itself,
They could not.
they have shown.
We have filed an affidavit indicating their financial position, Your Lordship, as directed by this court.
Where is that? Filed on?
23rd October, Your Lordship, 2025.
25.
Your Lordship.
25 additional affidavit. In page 8, my lord, the Williampur Secondary School shown total balance is 5,000 only. Then the next school, Magurmari, it is balance shown 0. Janomangal, balance shown 0. Next, Barangapara Secondary School, balance 5,360.
Financial solution will be low.
Novajyoti also nil. BNA balance 200 only.
So all the schools are similarly situated.
Yes.
But Your Lordship, before they...
So each school 3 lakh something.
Your Lordship, and this amount is only for the period of 2007 to 2016, Your Lordship. Only for this particular period.
So the entire amount for all the schools will come to how much?
I'll have to take
They're quite
instructions,
sizable.
Your Lordship.
20 lakhs.
64 lakhs.
64 lakhs.
Yes, ma'am. Start is there, not release order, na? Mm, 64 lakh 72,800.
All the schools.
All schools.
How do you resolve this? It's impossible.
Yes. Well, here in this case, our only grievance that has not been deducted from our salary. That has to be recovered from the managing committee. That is the business, government and managing
That
committee.
is what, because that's why the grant in aid now is given.
Yes.
So salary is given before it's given lump sum. Correct?
Yes.
Now what's happening is that because the appointment sanction post only, so to increase transparency, it's given, personally to each teacher.
Yes.
So what they're doing to recover that, they are
Yes.
deduct from each of the teachers.
Yes.
That's the thing. If it has happened that they give lump sum,
Yes.
they were deducted from the lump sum grant
Yes.
only. Then you've been
Then altogether different
Then
thing.
what the managing company does to you, that's up to them.
Yes.
That's the only thing. But in this case, because now there's no payment as a lump sum grant, it comes, individually to the teachers.
Yes.
That's why government is also recovered.
Yes.
How much money have you recovered so far? From your any amount recovered? Not yet.
Not yet recovered.
Then that's all right.
But as per the stay order of this honorable court, they are stopped to deduct it.
No, they had not deducted it
Not.
yet.
After this order, they have not deducted.
Click down here. So
1 lakh 1 hours. Already 1 lakh 10,000 13,300 deducted from each teacher.
Yes. This matter, which has received the attention of this court on various occasions with regard to the issue of recovery of arrears which were allowed by an order of the division bench of this court dated 4/3/2015, passed in writ appeal number 37 of 2014. with a further direction that the said amount spent in paying the minimum of basic salary to science teachers over and above the grant in aid be recovered from the resources of the managing committee. On this aspect, the matter had reached a stalemate in view of the fact that the managing committee, this is one school, this is all schools.
All schools, Your Lordship.
Yes, in fact, that the schools in question have expressed their inability to satisfy this amount. And in this context, have also stated the same on affidavit before this court. Stop. It will be relevant at this stage to refer to an earlier order passed by this court dated 4/4/2025, which will clearly reflect this fact. Stop. Today also, the same situation remains. And though recovery by the operation of interim orders of this court, recovery from the teachers by operation of interim orders of this court has been suspended. The question as to how the managing committee will satisfy this amount still remains. Stop. Stop. On a query from this court, it has been submitted that the total amount for involved for all the schools is rupees
64 lakhs
72,800 rupees.
64 lakhs 82,000
72,800 rupees, Your Lordship.
800 rupees. Next paragraph. In view of the inability as expressed by the respective managing committees to satisfy this amount to be recovered by state respondents. Stop. It is to satisfy the amount. This matter, in view of the this court, in the considered view of this court, it would be expedient if the state respondents consider this matter, that is, with regard to the, let's say, waiving this recovery.
Your Lordship.
With regard to waiving recovery, so that the schools cannot be put to great so that no, so that when this waiving this recovery. Stop. The state respondent therefore is likely to take instructions in this regard as to the possibility of such an approach, so that the matter can be closed.
Your Lordship.
Otherwise, special grant left to give all the schools.
Yes.
We'll not
But
say
Your
that
Lordship,
here.
in order to in order to be given recognition, also the schools have to be able to show that they can bear the financial burdens, Your Lordship, of running the school.
Yeah, but then they,
So this
but
is
you
also
already
part
recognize
and
them.
parcel.
Already recognized
Your-
long
Your
back.
Lordship, this is also part and parcel of that, Your
That is
Lordship.
what you obtain instructions
Your Lordship.
just after 3 weeks.
Right, in the month of July.
Month of July.
43 is a similar matter, Your
together.
Lordship.
Same.
50.
Hello. I want to submit a point, sir, over here. It is I'm most disturbed and harassed person over here.
No, wait, your matter will come. We'll take it up.
No, sir.
We'll take it up. Mr. Chopra, please sit down.
I will tell Mozika is only sitting over there in court number 1. He's not arguing.
Please sit down. We'll take up the matter.
I was sitting.
Yes, we'll take up the matter. We have lots of time. We'll take up the matter, yes.
But
Mr.
from the last.
Gupta, tell Mr. Chopra to calm down. I know it's agitated, yes. Please. Yes. We'll take it up. We'll take it up. Don't worry. We have enough time today.
I'm so obliged. I'm so obliged.
50.
Please, Lordship.
Where's MS Emerchang? You go and get instruction from his senior whether he will come now. After this matter, we'll take up this. Yes. Yes.
Yes, Lordship. Lordship, this is the petition against the order dated 10/12/2024, when it passed by the Chief Executive Member of GHDC, whereby these orders have condoned the delay of 3,442 days, my lord. Now, initially, what happened, Your Lordship, the brief fact of the case is here, Your Lordship, that the petitioner hearing, he is the daughter and son and daughter of last recorded Nokma, and at present also he is a Nokma. Now he, after the death, after the expiry of his her parents' lordship, they have filed an application before the executive member of JCTC for registration of Nokma civil lordship. The EM in his order dated 12/06/2007 passed an order allowing them to register as a Nokma. However, your lordship, the petition has been filed by the private respondent herein, objecting to my order registration. But then,
okay, come to the main point.
Yes, lordship.
Main points again now has been condoned. This court had passed on 2019.
Yes.
From Annexure 5 is that permitted them to seek application like long delay and seek recall order dated 12 March 2010. Correct?
Yes.
Then
the contention of my lord,
let me submit. You go and fight against on merits.
The main contention, my lord, is that we have not filed a separate application, my lord, for recall. That we have done, my lord. That is the main contention, my lord.
Let me complete because I'm the petitioner. They can reply.
Of course, you're a petitioner. Yes. This is your case. You're the master of your brief.
Now,
yes.
Even in the application, my lord, in the page 51, where they have stated they have not explained even there is not even a whisper of the reasonable ground or the reason for delay in filing the petition. That is the main subject matter here, because they have come after about nearly 10 years for filing an application for continuation of delay. Even in that, even in the application, they have filed a defective application. Even then, the court has condoned. As per our calculation, it was more than 4,000. They have stated 3,000 something. There is so much defect even in their calculation and also in the petition. In the petition, my lord, in the page 50, they have even reflected the wrong WPC and the order number. They have quoted it wrongly. So I have indicated even in the page 51 of their application, and then and the para 4 of their application, which they have filed for continuation for condoning the delay, lordship, they have not mentioned specific ground for condoning the delay. What they have stated is only that para 4. May I just read it? Yes. They have just stated that the following are the reason for ordinate delay of 3,042,000. Yeah. This in application for record of the order dated so and so for rehearing of the appeal. That the delay was not intentional nor deliberate, but was due to the circumstances beyond control of the applicant. That order dated 12/03/2010 JT so and so was not informed by the council on the account of the applicant conducting the matter, and as such the applicant were in dark about the said order for many days. The C they have given, applicant visited the conducting council in the month of June 2010, not knowing about the passing of the impugn order so and so, but the conducting council neither informed about the said impugn order nor disclosed the status of the case. These are the ground which they have mentioned it, but they have not mentioned the reason, the real reason why they have delay in filing the condemnation for recalling the order. My lord, if their conduct is this order, the original order was passed, your lordship. Just
so we'll do one thing. See, this is one aspect of coordination always. Now, firstly, in this case, we're not bound by the strict rules limitation. Okay, we go by what the 3 principles is justice, equity, and good conscience. Correct?
Yes.
Now, secondly, is that this court, by order, that 2019 order, had specifically directed that since they were illiterate and they were not informed, so on and so forth, that they were to make an application, and the CEM, in his discretion, shall decide the matter. Now, once a court allows a court to exercise discretionary powers, then in appeal, normally courts don't interfere in exercise discretionary power by the lower courts. So in this case, also you pay court 2,000 to Mr. Moment and let the matter be restored. I mean, let the matter carry on. Okay.
Yes, but one can be appreciate the order.
Yes, okay, we might say that maybe the cost day-to-day application cannot be there. But the thing is that you can if their situation from what they've shown here, they try to show that they are illiterate, and it's because the council who are not informed property that they were not aware that the order had been passed. So later on, when they came to know, they've made step, they've come for this court, then we dismissed asking for separate copy of condemnation application. So let me condone. Why you are scared? That if they come and contest the matter, you'll lose your knockmashim.
What has fallen from my lord? The same argument was my friend giving in his matter, where delay of condemnation application was dismissed. And he took the shelter of this, my lord, they are poor, they don't know, my lord, they are uneducated, lawyer is not informed, and now he is giving a opposite version.
Different case. Doesn't matter. He can,
Yes.
As per what has placed before this honorable court from the day one by the petitioner is that an application, a separate application for delay of condemnation was not filed. That is not correct, my lord. We have the record, that application is there.
Okay, then we will dispose it off. My lord. Any submission to make with the moment?
No, that is the only submission, my lord, that we have filed a separate application, my lord.
This petition is directed against an order dated 10/12/2024, passed in. There's no case number also.
Yes, that is
passed in.
This case number, my lord.
Passed by the chief executive member, GHADC, in REV capital /
GDC.
H-stop R stop case number 47 A capital / C of 2023, whereby a delay of 3,442 days was condoned in preferring the appeal.
Yes,
for recall of
application for recall of
order dated 12/3/2010. For yes, for filing an application to recall an order dated 12/3/2010 in so and so. Six per paragraph, right? So, if Mr. P.T. Sangma, lead counsel for the petitioner, has submitted that the respondent's number here,
here I am respondent number.
You are in this case, your respondent number.
Here in this case, my lord. I'm the petitioner, my lord.
Not this case. This is a main case.
Oh, I'm
4 and 5.
4 and 5, my lord.
Yes, 1-5, who were the appellants before the court of the chief executive member, have hopelessly failed to provide any sufficient cause to warrant the condemnation of delay of 300,442 days. Another counsel has drawn attention of this court to the application. Where's that page you showed, Alira?
Yes, page 50, my lord.
50?
Yes, page 51 actually, para 4.
Yes, continue this court to the application file for condemnation and has referred to para 4 to show that the reasons set out therein will not amount to sufficient cause for condoning delay. We therefore praise that the writ petition be the impugned order be quashed and repression be allowed. Stopped. Mr. A.G. Moomin, appearing for the response 4 and 5, has submitted that the delay, the reasons for the delay in filing the application for rehearing the appeal are genuine, and there has been no intentional or deliberate act on the part of the respondents do not pursue the appeal and right earnest. So, the counsel submitted that due to these circumstances and in view of the respondent being illiterate and unaware about the procedural law, they be given some consideration. Stop. Mr. Day, nothing to say.
My lord, my submission is in twofold. One is, my lord, that liberty was given by this honorable court for us to decide in independent.
Yes.
We have decided, my lord.
Yes,
Second
Mr.
thing, that the justification was given by the client of Mr. Momin,
Yes.
who the court was satisfied, my lord.
Mr. S.D. appearing for respondents 1, 2 and 3 has submitted that the CM had taken up the matter for considering the condemnation on the directions of this court contained in order dated, was it 19 order? Contained in order dated
10/12/2024.
No, of the High Court. Of
The High Court is 15/11/2023.
Order dated 15/11 or 23?
15/11.
19 order.
9/7/2019.
9/7 passed in WPC number
150 of 2017.
150 of
2017.
Which doesn't stop. He further submits that when the matter had again travelled to this court by way of WPC number 277. No.
Yes. No, my lord. 35, my lord, of 2023.
35 2023, my lord.
Travel to this court by way of WPC number 35 2023, wherein statements have been made that no separate application for condemnation had been preferred. The same he submits was not correct.
It was not correct.
From the records, it revealed that there was a separate application for condemnation. He therefore praised that petition be not entertained and the same be dismissed. Next paragraph. This court has considered submissions made by the council parties, also examined the materials and record. It is seen that by order dated 9/7/2019, passed in WPC number 150/2017, more particularly at paragraph 6 thereof, this court had directed as follows. Quote number 6, bracket paragraph number 6 quoted, yes, paragraph number 6 quoted below. A perusal of next paragraph, a perusal of the above quoted paragraph would show that the writ petitioner was permitted to go before the chief executive member by way of an application seeking condemnation for long delay, and that the chief executive member in his discretion was to examine the same on its merit and path orders thereon. It appears that in spite of the intervening proceedings, wherein the matter had again taken up by this court, the chief executive member by the order dated last order dated 10/12/2024 has examined the matter and in his discretion has found the same and in this decision has condoned the said delay in filing the application in the filing the application by the respondent 4 and 5 to recall of an order dated to 2010. So, in the considered view of this court, therefore, as the order dated imprint order is as the imprint order, in the view of the court, therefore, no interference will be called for, taking into account the circumstances surrounding the entire issue and the order of this court dated 9/7/2019. Of the writ petition is accordingly. However, you pay him 2,000 costs.
Lordship.
Yes, however, should we record?
Yes.
Why should we give cause? Doesn't matter. Just for his feelings. Yes. From the last line. One can call for NS in the good call, comma, taking into consideration the surrounding circumstances. Huh? (907) 2019. So and so. So only the reparation stands. It's closed and disposed of.
Lordship.
Valuable.
Yes.
Much pleasure, Lordship. Lordship, this
There are two matters, hearing matters before I pick
Lordship,
up.
I am seeking some indulgence in this item number 51, my lord. We will come later after maybe after 1 week to get some.
The service matter?
This is regarding
non-payment of salary, my lord.
After 2 weeks.
Lordship. Much pleasure, Lordship.
Who's then 54?
54.
Yes.
That may be taken up after 2 weeks as the Mr. Pathak is on legs.
Yes. After 2 weeks.
But there's also lump sum compensation. Can be clubbed.
After 2 weeks, yes.
Supplementary.
Yes. You just give me 5 minutes, huh?
But only I was quite awkward position. 2 fixed matters today, my lord. The next matter is to be called out. All other matters have been discharged by division bench. It lordship kindly accommodate 2 o'clock.
2 o'clock. We'll take up 2 o'clock.
It is not taken up also. I'll adjourn.
Mr. Gupta. Mr. Gupta, 2 o'clock. 2 o'clock. Yes. Let Mr. Dr. Mazai finish his other matters. Yes. Yes. We're taking up the entire matter for hearing, correct?
The main matter was argued, my lord. If main matter, it appears that after disposal of this missed case, my lord, the main matter has to be, but the main matter was already argued, my lord. We can refresh,
That has already been
but that may not be possible today, my lord. Main matter may not be possible today.
We'll finish on this missed case now?
Yes, my lord.
Yes, my lord.
Who's argue? Mr. Gupta?
Mads, I'll just take 2 minutes, my lord.
2 minutes, 2 minutes only, because you tend to linger a long time. Yes.
Mads, this matter, otherwise, Mads, once my learned senior responds, then I will be addressing certain points.
Exactly,
But
that is
just to
what.
apprise-
So just
to apprise what has happened in this case, my lords, may kindly have the order of 24th April 2026. In the application, 24th April 2026.
Page?
But the order, 24th April, in this application, my lords, it's your lordship's order of 24th April. I read that day before yesterday also, my lords. 24th April 2026.
Where's the order 24?
This is order in miscellaneous application.
In this case,
on
okay.
28th of 26. Yes, my lords. 24th April. In this application, it was. This is the order by which the notice was issued.
Yes.
So I'm reading from page number 2, para number 3.
Yes.
The learned counsel submits that even in this order dated 10th of April 26, with regard to another officer wherein the recommendation has been kept in sealed cover, details have been given as to the compliance of the orders of the Sikkim High Court, whereas he submits that in the case of the petitioner, even though the matter was before this court wherein the your lordships may have the last
Just read para 3 again, because you had broken off just now. Yes. Just read para 3 again.
The learned counsel submits that even in the order dated 10th of April 26, with regard to another officer wherein the recommendation has been kept in sealed cover, details have been given as to the compliance of orders of the Sikkim High Court, whereas he submits in the case of the petitioner, even though the matter was before this court wherein the corrigendum and charge sheet has been quashed, there is no mention of the same. He therefore prays that the instant miscellaneous application be given consideration. Your lordships may kindly have the last paragraph of this page. Though noting the submissions of the learned DSGI in view of the developments which seem to be serious in nature and having a bearing on the matter in the pending judgment, the learned DSGI is directed to obtain instructions within 10 days. Now, it's just one page I want to show. Your lordships may kindly have my application. Page number 26. Which is being heard today by your lordships. Page 26.
Yes.
But in this case, the judgment was reserved on 8th of April. 10th of April is this order. Your lordships would have the first paragraph. The president is pleased to promote the following superintending engineers to the post of chief engineer. Then your lordships may kindly have para 2.
Yes.
As per the recommendation of DPC in respect of the following officers in sealed cover, your lordships marked that, and promotion of 2 junior most officers on the panel to be kept on ad hoc basis. The name of petitioner is serial number 2. Your lordships, the third paragraph is after reading which your lordship said that this is serious in nature and instructions have to be obtained. DGBR is requested to take further action on the DPC recommendations in respect of Navneet Kishore Dikshit, who is in sealed cover, and for complying with the order dated 19th February 26 of the Honorable High Court of Sikkim, Gangtok. DGBR is also requested to proceed towards opening of all sealed cover cases which may be affected by this promotion order. My lords, my contention was that the judgment of 24th November is prior in time. It is a final order, has attained finality. But the sealed cover procedure could have been adopted in view of Janki Raman only in 3 circumstances: charge sheet issued, suspension, and my lords, the third would be the criminal prosecution. In my case, EPC is held on 10th of December 2025. Your lordships may kindly make a note of it, my lords, at my request. So as on the date of DPC, no charge sheet existed. Merge the respondents, why this 10th April, they make a mention of the 19th February 26 interim order of Sikkim High Court, but they do not make a mention of your lordship's judgment of 24th November 25 for opening of sealed cover. But on this aspect, the respondents had to obtain instructions, and that is what I wanted to just refresh your lordship's memory.
Yes.
My lord, I'll just put things in perspective, my lord. My lord, I'll refer to page 26 again, my lord. Of the,
yes.
My friend was referring, my lord.
Yes.
My lord, the writ petitioner is presently serving as superintending engineer. He is one of those, my lord, who are due for promotion to, or they are chief engineer civil, my lord, in GREF border roads ordination.
Yes.
Now, my lord, in 2026 vacancy year, this particular vacancy year, 10 vacancies are available, my lord.
Yeah.
So 10 officers have to be promoted in terms of seniority. Primarily seniority is the basis, my lord. Now, if your lordship kindly see, and my lord, the zone of consideration is vacancies multiplied by 2 plus 4. So since the vacancies were 10 here, my lord, so zone of consideration will be 10 into 2, 20 and plus 4. So 24 officers were to be in the zone of consideration to be considered. Now, because only 15 officers are available in the department, my lord, so zone of consideration was restricted to 15 officers. Now, all 15s are mentioned in this page 26, my lord.
That is 10 plus 3 plus 2.
Now, yes, my lord. Now, what is very important here, my lord? My lord, 1 to 10 are in order of seniority. Now, extended list 1 to 3, they are also in order of seniority, my lord. Now come Navneet Kishore Dixit, for whom Sikkim High Court is given some order, my lord. Now he is junior to number 6 in the list, my lord. Suresh Kumar Verma is number 6.
Yes.
So he should have been at number 7, but because of pendency of the matter, he has been kept in a separate list. And the writ petitioner is junior to number 10, my lord. So, my lord, if Mr. Saxena comes in, Mr. Dixit comes in, my lord, he is out of zone of consideration, my lord. He becomes number 12, my lord.
In his panel of 10?
Because vacancies are 10, my lord. There are 10 vacancies. That's what 10 names have been notified.
So you mean to say that if the name was not sealed covers, he'll not be that.
No, I'm not saying that, my lord. But the urgency is shown in the matter, my lord. Otherwise, he is number 12.
Okay, from where do you get that he's number 12?
My lord, I get, because 1 to 10 you lots of seen in this list. They are in according to their seniority, my lord.
Okay, there's 1 to 10.
1 to 10.
Virinder Singh up to Thang Kom. Right.
Now, the writ petitioner is junior to number 10, my lord.
Now, just come to extended panel to operate in this order, leave the officers in the main panel, extended panel retiring, that we can see.
Yes.
Okay, fine. Extended panel, that means 3 officers are kept in the reserve.
Kept in reserve, and I'll explain why they are kept in reserve, my lord.
Now, then where will his 2 other officers come in then? This before come seal cover.
But seal cover, Navneet Kumar Dixit will come at number 7, my lord, just after 6.
So what will happen to the extended panel then?
I'll explain that, my lord. Now, why this has been done. So, Dixit will come at number 7, my lord. Then the existing 10 will become 11, my lord.
Yes.
And then the petitioner will be the next to him, my lord. So, he'll be at number 12.
See, read this paragraph 2. Yes.
I'll explain now, my lord. Now, why 3 extended panel has been kept, my lord, is because of some retirements in the offing, my lord. Because some of them are due to retire within this 2026, my lord. So that's why, as and when they retire, the extended list will be absorbed against those vacancies, my lord. So that's why 3 positions have been kept.
So these 2 officers, petitioner and Navneet Kishore Dixit, they're senior to the extended panel.
The senior to extended panel.
Okay.
So my clear, my lord. Mr. Dixit will be at number 7 and writ petitioner will be at number 12.
So
at the most,
it is accepted that the petitioner is junior to Lumley Thangkom.
My lord.
That is a settled position.
That is settled position, my lord.
Okay.
As per my instruction, my lord.
Yes.
So he will be at number 12. So maximum chance he has is of getting into extended panel, my lord.
Right.
He has no chance of coming in first 10. So extended panel as and when vacancies will arise, if everything is all right with his ACR and his DPC recommendation.
Of course, other opinions. Yes.
Now, my lord, your lordship is seen number 9 and 10 who have been promoted here. It has been mentioned here, my lord, in para 2. Para 2, kindly see, my lord.
Yes.
As per recommendation of DC, in the following officers in seal cover and promotion of 2 junior most officers in the panel to be kept on ad hoc basis till finalization.
Yeah.
So number 9 and 10, because if they come in, my lord.
What
so that's why
is that this number 9 and 10.
Yes.
At the most, number 10 will go.
Yes. No. Because
if you slot
number 9 and 10 both will go.
If you why? If you slot in this Navneet Kushod Dixit, like
Navneet will come at number 7, my lord. Yes.
Will come at 7, and then
yes.
if the petitioner
then Com becomes 11, my lord, and then
to Com, then
he becomes 12.
Com will go, right?
Yes.
Because it will be 10 to maintain 10, yes. And then this Pankaj Goel only will Pankaj will remain. Now,
but anyhow, my lord, the last 2 promotions, the junior most have been kept ad hoc, my lord. So that.
See, if you say that the petitioner is junior most at item 12, so even if the seal cover is opened, and
at the most he'll get into extended list, not in the main list.
Exactly. And so now, then why should this Pankaj Goel go then number 9? If you're going to insert only this Mr. Dixit,
the Pankaj Goel will still be there, my lord.
Then.
Normally that may not be very relevant, my lord. Now, what is relevant here, my lord?
Then why have they kept 2 ad hoc promotional posts? That means will the petitioner be in contention in some other way?
No, my lord.
No.
No.
Okay.
He is at number 12, my lord. Now, much has been made about para 3, my lord. Much has been made about para 3, my lord.
Yes.
I'll just read para 3 once again, my lord.
Yes.
It says, Directorate General Border Roads is requested to take further action on the DPC recommendation in respect of Sri Navneet Kushod Dixit, who is in sealed cover and for complying with the order dated so and so of the Honorable High Court of Sikkim Gangtok. Then, my lord, there is another sentence after that. Director General BR is also requested to proceed towards opening of all such sealed covers cases which may be affected by this promotion order.
So,
he is also one of the sealed cover, my lord. And there is a specific direction to open his seal cover also.
So then why has been kept seal cover at all in the first place? That is what is put.
I'll explain that also, my lord.
Why? Why if there's no, it's not a suspension.
I'll explain that.
He's not been charge sheeted. There's no criminal case against him. The case has been over. The charge sheet was quashed. Then what remains now?
I'll explain that, my lord.
Yes.
My lord, against him memorandum of charge was issued on 20th of April 25, my lord.
Okay, I don't remember.
Those records are not here, your lordship, but memorandum of charge was issued on 20th April, my lord. Process of DPC started in August 2025, my lord.
August 25,
my lord.
But DPC sat on 10/9.
Yes, the process of DPC, my lord, is a long process because there is a consultation from.
Okay, yes.
There is a long drawn process, my lord, and to show that, my lord, I'll just place to some documents, your lords. So first which lordship will see. Process was started in August and 19th September is the date, my lord, when the matter was formally forwarded for convening DPC, my lord.
What? Yes.
Now, lordship passed the judgment in early writ petition on 24th of November 2025, my lord.
24/11.
24/11/25.
Okay.
So when the DPC process was initiated, memorandum of charge was pending against him, my lord.
Yes.
24/11 it has been quashed, and it has been quashed by lordship, because I'll place that order because the printout is not ready with me, on technical grounds, my lord, and lordship has given us the liberty to proceed afresh, if so desire, in accordance with law. Matter was examined, my lord, whether to file an appeal against that order or issue a fresh memorandum of charge, my lord. So ultimately the department took a decision that will comply with the order of your lordship. And then your lordship will see, next page, my lord.
Yes.
11 May 2026.
Yes.
Proposal has been sent to the ministry, my lord, for opening of the seal cover in accordance with your lordship judgment, my lord. But your lordship judgment, I must point out here, my lord, lordship simply quashed the memorandum of charge, my lord, gave us liberty to proceed further in accordance with law. There was no further direction in that writ petition, my lord. In fact, that was not even a subject matter that opened the seal cover. There was no such specific direction in that, my lord.
Correct, correct.
So unless that such direction is there, that is again a different cause of action, my lord. For that, they need to come and file a fresh writ petition that in spite of that order quashing of the memorandum of charge, seal cover has not been opened. They don't do that, my lord, and allege that we have committed contempt to the order of this honorable court, my lord. Which order? Contempt of which order, my lord? Well, unnecessarily sensationalizing the matter.
No, but
crying wolf.
But see, but that is a like natural corollary to what happened. If you're not proceeding any further, then the natural corollary be open a seal cover. If on that given date you're not proceeding any further.
DPC was held on 10th December 2025 itself.
Now 11 May 2026 when he took this, considered decision.
No, my lord, those two dates are very relevant, my lord. Lordship quashed on 24/11/25.
Right, 24/11/25, 19/9/25. The DPC motion was put in motion. Correct.
DPC actually held on 10th December 25, my lord.
Okay.
After 10 days. Now a DPC is a comprehensive package, my lord. That cannot be interdicted now, my lord, within 10 days.
How come the other document, Dr. Musika, we've supplied this 11 May 26. Now why in 5 you say that?
My lord, this has come after this page 26, my lord. Kindly see page 26 of 10th April 26.
Yes.
You are using that. Here is a direction, my lord, from ministry that you proceed with opening of the other seal covers, including Mr. Dikshit and whoever is affected by this. Am I clear, my lord, on that? This order is of 10th April 26.
No, why have you forwarded this consideration? Why you kept it pending again? Now you have observed in your this 20 in your 11/26. Just come to the second page.
Yes, ma'am.
Okay. Yes. You come to paragraph 4. Right. He doesn't have he's not a competent authority to direct for opening. See, the above named officer has now been cleared from vigilance angle. Vigilance clearance certificate been prepared on the basis of so-and-so, furnished by so-and-so, original copy. In view of the above proposal for consideration for opening of seal cover in respect of ordinary officer is forwarded herewith for further necessary action, please.
So to write to ministry for permission to open the seal cover, my lord?
Yes. That's been
because there is some official procedure, my lord. Though there is a direction by your lordship, my lord, but my lord, there is no direction by your lordship to open the seal cover, my lord. I'm only just trying to. Consequential. I agree, my lord. It is consequential, but it is not a direct consequence, my lord, because your lordship has given us direction or liberty to proceed afresh in accordance with law as well, my lord, in that order.
Right.
So we examined whether.
So if we've examined and felt that no, forget it, we will leave it at this. We claim the vigilance angle.
So that may take some time, my lord.
That means the whole slate is wiped clean.
Wiped clean, my lord, but it was not wiped clean on 10, 12, 20, 25, my lord, when the DPC.
Wiped clean, you can't keep another little, thing remaining.
My lord, the slate was not clean on 10, 12, 20, 25 when the DPC was held, my lord.
Right. Right, okay. Fine. So what impediment is there now?
Now there is no impediment, my lord. We have sent for DPC. The moment we get a direction from MOD or approval, we will open it, my lord.
Open the seal cover.
We'll open the seal cover, my lord, and the consequences, what will the consequence?
Yes.
My lord, this is totally red herring misapplication, my lord, in a reserved judgment. In a reserved case, because knowing very well what will be the outcome of the writ petition, my lord, just to frustrate or thwart the judgment to be passed in the writ petition, my lord, the file is this case, my lord. To put pressure on the department to give him promotion in spite of maybe not correct ACR, my lord.
The ACR is another aspect, but I think is
But
that.
my lord, why will they file a miscase, my lord, in a concluded reserved judgment matter, my lord?
Of course,
and where the issue was ACR, my lord. Had they filed a miscase in previous writ petition, my lord, for a consequential direction that they open the seal cover, when the lordship quashed the memorandum of charge, that could still be understandable, my lord. But why they filed in this? Just to thwart the lordship will release the matter from reserved or something like that, my lord, and they'll call defense secretary to the court, put pressure on them, give him promotion, my lord.
May I, my lords?
So, my lord, in my humble submission, this application has no merit.
Where's the objection? All these company objections.
I submit.
Okay.
Lords, may I just submit?
Yes, please. 1 second.
What has? I'm so sorry.
1 second.
Very well.
My lord, the date your lordship has raised the query, why May, my lord? Because page 26 is of 10th April, my lord. When the direction is that to open the seal cover of Mr. Dikshit and as well as other officers affected by this, my lord.
Has this come in affidavits?
No, my lord. Because just yesterday I got instruction, my lord.
Has he, Mr. Gupta, you've seen a copy of this? 11.
Lords, I would not need to. Lords, I don't.
11/26.
I would in fact. Lords, I would in fact address your lordships and my lords, from whatever is already on record, there is a reply which has been filed by the respondents. And my lords, before I start, I must say, my lords, this matter which I thought the nature of this matter and the nature of arguments which have to be addressed. My lords, I must say the learned senior counsel has completely changed the texture. But my lords, I would not go beyond what has been stated on record by the respondents. Your lordships, there is a reply which has been filed by the respondents in terms of the direction of your lordships, which is 18th of May. Your lordships may kindly have the reply filed by the respondents for this application. But may kindly have that for a minute. Lords, 18th of May it is dated, contains no document. Something which is being given to your lordships today is dated ante to this affidavit, but still not filed. Anyhow, your lordships may kindly have page 3, para C of this application.
Yes.
The allegation of institutional retaliation is wholly denied. Has your lordships got that? All actions taken by the respondents, including processing of APAR, consideration of representation, initiation of disciplinary proceedings, and conduct of DPC, have been undertaken strictly in accordance with the applicable rules, procedures, and administrative instructions. What's the first question is, what are those applicable rules? 2, my lords, clause E, and my lords, I would rest my case after reading clause E and F with respect to my first argument. The allegation regarding illegality of sealed cover procedure is specifically denied. It is submitted that at the relevant time of DPC, 10th of December, the charge sheet dated 22nd April was in existence. This is a statement made on oath by the respondents who have been apprised that the issue raised in this application is serious in nature. The respondents before your lordships are the members of the DPC, the Defense Secretary and DGBR. They are 2 of the 3 people who are sitting in the DPC, and they are respondents in this case. They are the respondents in 24th November judgment, and they say that DPC, the day it was held, that charge sheet was in existence. The applicant was not clear from vigilance angle. This is not a statement made on oath. Accordingly, the sealed cover procedure was invoked strictly in terms of OM dated 14 September 92, which mandates such course of action to be taken. But I will read that OM, which is a part of my application. Next paragraph, Lords. The applicant's contention ignores the settled position that validity of administrative action must be assessed on the basis of facts prevailing at the relevant time Subsequent developments, including of charge sheet, do not retrospectively invalidate the lawful decision of DPC. So much, this is how the cart has moved. April 25 charge sheet is issued. 24th November 2025, the charge sheet is quashed. Manoj is not having the copy of the judgment of 24th November 25. I have serious objection to the contention of the respondents that it was quashed on technical grounds. Manoj, I am supported by, because the fact is your lordships only passed that judgment. Your lordships used the word that this charge sheet is visited with incurable defects. That is the word your lordships had used in that judgment, but the respondents choose to focus on just one word which has been used in the whole judgment. 24th November, the charge sheet stands quashed. 10th December 25, the respondents who are aware of the passing of the judgment hold the DPC, and my lords, they put my name in sealed cover in contravention of Janki Raman and in contravention of this September 1992 OM, which I will read after this. So much, the two positions which emerges, they talk about some applicable rules. What are those rules? No mention. Two, they say on the date of DPC, the charge sheet existed. If this is not disrespect to this honorable court, then Murds, I don't know, I'm at loss of words, what would be. Your lordships may kindly have para 6, page 4, para 6.a. It is submitted that the applicant is selectively relying upon certain facts while suppressing material aspects, particularly that the sealed cover was applied due to subsisting disciplinary proceedings at the relevant time. Murds, when this serious allegation is raised on the respondents, is it not the duty of the respondents to come with the fact and detail and documents? What is the purpose of this 11th May letter, which could have been very well filed with this reply, was chosen not to be filed? Repeated delay, my lords, adjournments taken, and my lords, now where the time of final argument comes, certain documents are being handed over to show the compliance. Now, my lords, I will show what is the nature of compliance by showing just relying on one document. Your lordships may kindly have my application, and your lordships may kindly have the page number 31 of my application, my lords. I will show 5 more points from their reply which will invite contempt, my lords, but to show what is that applicable rule, your lordships may kindly have my application, page 31. I'm sorry to say, my lords, but this is a classic case of where you can't convince, confuse, and when you can't confuse, delay. And my lords, now put the blame on the petitioner who's being harassed and victimized. Page 31 of my application, my lords.
Yes.
Your lordships may have the typed copy of the OM of 14 September 1992. Has your lordships got that, my lords?
Yes.
My lords, I'm reading the last paragraph. My lords, before that, your lordships might have marked from the last time. My lords, in view of the judgment of K.V. Janki Raman, the department had issued this OM, my lords. In the first paragraph, 4th last line. Has your lordships got that, my lords?
The first, the 31. Yes.
The OM of 14 September 92.
Yes.
The first paragraph, your lordships, in the last lordship sees K.V. Janki. Since our judgment changed, therefore this 92. And words, the respondents have also mentioned about this in their reply. But I'm reading paragraph 2. At the time of consideration of cases of government servants for promotion, details of government servants in consideration zone for promotion falling under the following categories shall be specifically brought to the notice of the DPC. There are 3 conditions. I will not read in detail. One is suspension. Second is disciplinary proceedings are pending and charge sheet is issued. Third is that the criminal charge is pending. But admittedly on 24th November, once the charge sheet, the sole charge sheet against me stood quashed. But there was nothing which survived against me, not 10 but 16 days. It is not 10 days, Murds. 24th November and 10th of December, 16 days later, nothing existed against me. Murds, that is where the respondents have ended their argument. But Murds, respondents should apprise this honorable court of their own rules and policies. Murds, this very OM deals with this very aspect. Your lordships would have page 32.3, Murds.
Yes.
Action after completing of disciplinary case and criminal prosecution. What is the procedure to be followed after that? On the conclusion of the disciplinary case, criminal prosecution, which results in dropping of allegations against the government servant, the sealed cover or covers shall be opened.
Yes.
Mandatory, my lords.
Yes.
It is mandatory. What's your lordships may now kindly have page 33.4. This is not relevant to me, but very relevant. 6 monthly review of sealed cover cases. It is necessary to ensure that disciplinary case criminal prosecution instituted against any government servant is not unduly prolonged, and all efforts to finalize expeditiously the proceedings should be taken so that the need for keeping of a case of the government servant in sealed cover is limited to the barest minimum, the intention. But consider my case that this disciplinary proceeding was continuing and they failed to do this review. Mine is a case, it stands quashed. Now, Lords, why I'm harping upon this? I would have otherwise not harped upon this. Lords, may kindly have their reply for a minute, Lords. I'm sorry, I'm just troubling your Lordships, but there's very important thing, page 6 of their reply. And I'm glad, Lords, this has come in the reply.
Yes.
Page 6 of the reply. Lords, I'm reading from the 4th line.
Yes.
Accordingly, memorandum of charges dated 22nd April and corrigendum of 5th August served upon the applicant by the disciplinary authority under Rule 14 of the CCS rules for delay in submission of so-and-so. The disciplinary case in respect of the applicant consequent upon setting aside of memorandum of charges has been resubmitted to the MOD on 3rd December. The action of opening the sealed cover to be taken immediately as per of 1992 OM from 24th of November happens on 11th May after the notice is issued in the present application. But the action for reissuing some DE proceedings against the 24th November happens on 3rd December, not even 10 days, my lords.
Yes.
But that it is not red herring, that there is no process. In that case, there is no administrative delay. If they have to victimize me, they will take steps within 9 days. But when they have to comply with your own rules and policies, it is only after I approach this court and notice is issued and they want to show their bona fide. Once 2 members of DPC are respondents and are before this honorable court even today. They were personally and officially aware of the quashing of the charge sheet on 10th of December. The first place, my lords, where the respondents committed contempt, and my lords has rightly, my lords, in my respectful submission noted, 24th November says all actions in accordance with law. What the respondents want is for every pole and pillar I should come to the court, and the first argument they take is that I have filed a premature petition. When I get the order in my favor, they say no, this is a separate cause of action, you file another case. That is the reason I'm doing this government job. I'm doing my job in public service, my lords. That is the my lords, reward I get for unblemished service of 32 years. My lords, just one judgment I want to show. My lords, may kindly have. My lords, I can show 10 more things. My lords, I'm just handing over one written submissions to your lordships. I have made my respectful submission with respect to everything which is stated at 14 places in their reply. They say that the charge sheet existed on 10th of December. At 12 places, they say that the judgment of 24th November was in our knowledge. Contrary view, they don't know what they have to say. One judgment of Nasimuddin Ansari. But it is against the same respondents, BRO, latest judgment merged 2023-24. And I will not read the whole judgment, lords. I will just take your lordships through the relevant part. What I'm reading from page 3, para 14. What's identical case as mine, my lords, against the same respondents. The petitioner then wrote a letter so-and-so, lords. I'm reading from the 4th line. The petitioner asserted that keeping the outcome of DPC in sealed cover after conclusion of DPC proceedings was illegal and requested them to consider him for a promotion from with effect from 10 to 11. I just wanted to show that this judgment is relevant to what I am asking for, lords. Against the same respondents, lords, BRO, BGBR and everyone, lords. They are habitual of doing this. They want to just punish the civilian officers for their honesty. Lords, I am just coming to page 10 now, lords. Page 10, para 58, lords, of this judgment.
How long is the judgment? Page 10 para?
Much page 10 para 58. But I am only coming to what is relevant to this case. I am not reading the whole judgment. Page 10 para 58. Muds, this is the paragraph in which the Honorable High Court came to the conclusion that all the actions which were initiated by the respondents were with malified intent. Para 59. Muds, as I said, I will not trouble your lordships in reading every paragraph. Para 59, the tenacity of the disciplinary authority to somehow penalize the petitioner is evident from the fact that despite the findings of the charges not proved twice, it still held the petitioner responsible and thus gave a disagreement note and sought the response of the petitioner. Manoj, may kindly have now page number 14, para number 80, Manoj. But 79 is also relevant, but I am reading 80.
I don't know.
May kindly know.
Because
I'm sorry, Manoj, allow me.
One second, please.
Yes, yes.
The DB matter I requested to take up at 3 o'clock. Well, you can conclude before that one.
Yes.
I'll take more than 1 minute. I'll take not more than 1 minute. 79 and 80 minutes, I'm reading 80. The scope under 226 minutes, this petition is under 226 and my application is in this petition. Your lordships, may kindly note, Supreme Court has said in the last 3 lines, wherein there was the finding of the misconduct is based on evidence, statutory rules governing the conduct of disciplinary inquiry were followed or not. Notes, all these considerations have to be taken, Malods. Para 81, the respondents have though charged the petitioner for evaluating 13 answer sheets incorrectly but have dismally been unable to support it by any evidence. We find that this is one case demonstrative of imposing penalty despite there being no evidence which calls for intervention of this court to exercise of its power under judicial review. Manoj, may kindly have page 15, para 87.
Yes.
The record and documents establish the blatant differential treatment that has been accorded to the petitioner vis-a-vis the other members of the BO against whom no action has been taken. That is what was the conclusion. Last month's Roman 5, predisposed mindset in the tentative disagreement note. That has been my case all along. The respondents have been proceeding against me with a predisposed mindset. The allegation was this against the very same respondents. But the findings your lordships would have at page number 17 and 18. Para 99, page 17. Against these respondents. This court is not hesitant to observe that in the light of the above discussed obstinate attitude of the respondents to somehow nail the petitioner, any statutory remedy was likely to result in the same fate. The exceptional circumstances of this case justifies resort to the writ jurisdiction as the petitioner has raised grounds of disciplinary treatment. Conclusion. As already discussed above, the petitioner was not found responsible for the irregularities in the so-and-so. Third line onwards, respondents' insistence to put a disagreement note despite the finding of charges not proved by inquiry reports only reflects the predetermined mind and malified intent of the respondents to impose penalty. The significance of the transparency and reasonableness in adjudicatory process by the disciplinary authority can never be overemphasized in disciplinary matters on which the entire career of an officer is dependent. Any wrong decision not only brings disrepute but also dampens the zeal to work with honesty. The competency in any department can be inculcated only by appreciation of good work and severe action against the delinquent officers. The respondents, being the appointed authority and responsible for the entire disciplined force, cannot be expected to work in such an arbitrary and non-transparent manner. The penalty imposed by the respondents is not sustainable. Thereafter, since it's a DB judgment, the co-judge in para 103 and 104 have made scathing remarks against the respondent as to how these respondents, despite being members of armed forces, they are acting without transparency. And I am not in any way different than this petitioner. But I have shown 9 days they take to show to this court that we are initiating again. But when it comes to following the policies of the department, even till May, my lords, they are just telling the honorable court that we are complying with the procedure. Now, my respectful submission in this case is, one, I have shown that despite the judgment of this honorable court, the sealed cover procedure was adopted. Two, my lords, I have shown that despite being brought into the knowledge of this fact to the respondents, still they continued to maintain the sealed cover. Three, my lords, that despite the filing of this application, it is only then, my lords, they file my lords, they are now coming up with the letter. They say that we are in the process of opening the sealed cover. What, my lords, when the respondents argued, my lords, they said that I am going to be in the waitlist panel. What they did not tell is, my lords, my promotion will get effective from next month or probably next to next month, even though I am in the waitlist panel. Even though I'm maybe 11th or 12th or 13th or 14th in number, because all the vacancies and all that which are going to arise,
my lord, if he's,
because of retirement.
If his ACR is good, my lord, DPC
No, forget aside. There's the fact that
then he'll get promotion from the extended list in July or August.
Then yes.
But the fact of the matter, this should have been also informed to the court. That there is no urgency, that is argued, but it should also be argued that by continuing to in sealed cover, even in July and August, I will not obtain it.
Yes.
But the only intent is to stop my promotion. My request is, in this case also, the Honorable High Court imposed penalty on the respondents for proceeding in a non-transparent manner. I have showcased 24th judgment is ignored, 24th November, 19th February interim order is taken into consideration. But that is how the conduct of respondents is. The respondents have to be called to the Honorable Court to face these proceedings, and they should be penalized. Otherwise, these army officers,
these lengthy submissions, can I just cut it short?
If they come for 2 years in my organization, I am a regular employee. They sit over me as my boss.
I'll just make a concluding submission, my lord. Kindly see the prayer in the miscase, my lord. I'm acceding to this prayer. What more he wants, my lord?
No, it is not the case.
Can you see the prayer?
It is the case of conduct.
Please.
My main petition says that they are victimizing me. They want to stop my promotion.
Yes, please. Can you see the prayer, my lord? Prayer A. Issue appropriate direction to the respondent particular MOD pertaining to so and so.
I'm really sorry.
And to act upon the DPC recommendation for promotion, my lord. That is direction to open the DPC, my lord.
They should have said so in the first date, my lords. I'm sorry, my lords.
If it's ego fight, let us make a submission.
Well, I'm so sorry. Sir, just give me a minute.
Yes.
Words, my prayer is to that effect because I issued a legal notice to them in April. Still, they did not open the sealed cover. Words, after getting this application argued for 6-7 days, and it's very bona fidely. My
lord, unnecessary, you have to make submission, there is no point, my lord. Their application, what is the prayer? I am acceding to the prayer. I filed an affidavit that your sealed coverage and in the process of opening, my lord. Now, can you see second prayer, my lord? Can this prayer even be considered, my lord? Direct the respondents to promote the petitioner. Now, that will depend on the DPC recommendation, my lord. How this court can direct, my lord.
My last submission is the conduct of the respondents ought not to be ignored. It will further embolden them to take the judgments of this honorable court at lightly.
I will not go that far. We'll just argue on the merit of the matter.
That's my submission, sir. Sir, that's my submission.
Yes.
With due respect, sir.
We'll pass order.
And the main matter will know. This is only in the miscase.
Yeah, miscase is we will pass orders. We'll pass it tomorrow.
Was the main case is already ordered?
No, main case order release. We already released part her. Release the main case. The main case listed tomorrow.
Main case, one.
Yes, for passing of. You want to hear it again?
I think we have to refresh your lordship memory.
Yes, then we'll have the main case next.
Well, after 2 weeks.
Tomorrow I have difficulty.
Okay, it's fine then.
May have it after 2-3 days.
Okay, 2 weeks. Yes.
2 weeks.
But 26th, my lords, if your lordships can consider.
Yes, we have a lot of other pressing matters, Mr. Gupta. We will tackle your.
I'm requesting. I'm requesting if your lordships can consider. 26th, my lords. Obliged, my lords. I'm so obliged.